The Supreme Court today handed down a major victory for gun control advocates.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
The majority of the court ruling the Constitution protects a person's right to carry a gun outside the home.
Businesses are welcome to put up signs that say this is a gun-free zone, but if you don't, then it's expected that you are able to carry on that property.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
The Supreme Court just dropped a bombshell that's about to change everything for gun owners across America. Every single firearm permit in all 50 states could be gone. Not reformed, not streamlined, completely eliminated. This isn't speculation anymore. The highest court in the land is hearing arguments right now that could end the entire concept of needing government permission to exercise your Second Amendment rights. What's happening in courtrooms across the country right now is creating a constitutional crisis that forced the Supreme Court to act with unprecedented speed. Federal judges are issuing completely opposite rulings about the same constitutional right. In some states, carrying a firearm without a permit is perfectly legal. Cross an invisible state line, and that same action becomes a felony punishable by years in prison. The Supreme Court had no choice but to step in. The case that started this avalanche began with something surprisingly simple. A group of citizens challenged their state's permit system with one devastating question: why do we need government permission to exercise a constitutional right? Their lawyers presented an argument so straightforward that even gun control advocates are struggling to counter it. They pointed out that you don't need a permit to speak freely, practice your religion, or invoke your right to remain silent. So why should the Second Amendment be any different? A federal judge examining this case made a discovery that sent shockwaves through the legal community. After reviewing thousands of pages of historical documents from America's founding era, he couldn't find a single example of permit requirements for firearm ownership. Not one. The founders who wrote the Second Amendment never imagined citizens would need to ask permission from the government to keep and bear arms. They viewed it as a natural right that existed before government, not something granted by bureaucrats. But what the judge uncovered next changed everything. The historical record revealed that permit systems didn't appear until the early 1900s, and their origins are darker than most people realize. Southern states created the first permit requirements specifically to prevent newly freed slaves from owning firearms. Northern cities implemented discretionary permit systems to keep guns away from Italian and Irish immigrants. These weren't public safety measures. They were tools of discrimination wrapped in bureaucratic language.
It also puts state laws in jeopardy that are similar to this law.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
The government may not regulate individuals' possessions of weapons for self-defense.
This ruling strikes down a New York law that put restrictions on who could get a license to carry a gun outside of the home.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
When this judge struck down the entire permit system as unconstitutional, everyone expected a quick reversal on appeal. Instead, something extraordinary happened. A 3-judge appellate panel not only upheld the ruling, but expanded on it. They wrote that requiring permits for constitutional rights transforms those rights into privileges that government can grant or deny at will. The moment you make someone ask permission to exercise a right, it ceases to be a right at all. The state demanded the full appeals court reconsider this radical decision. Every single judge on that court declined. That unanimous refusal sent a clear message. They believed the panel got it exactly right. Meanwhile, other federal circuits were ruling the complete opposite way, creating the exact constitutional chaos the Supreme Court exists to prevent. Then something happened that nobody saw coming. The Department of Justice under the new administration filed a brief that went further than anyone expected. They didn't just argue that overly restrictive permits are problematic. The federal government told the Supreme Court that any permit requirement for exercising Second Amendment rights violates the Constitution. Their position is absolute: no permits, no applications, no fees, no waiting periods for constitutional rights. The DOJ's argument cuts through decades of complicated legal precedent with surgical precision. They're asking why the Second Amendment gets treated differently than every other constitutional right. You don't need a permit to criticize the government, worship at your chosen church, or invoke your right against self-incrimination. These rights belong to you simply because you exist as an American citizen. The government's position is that the Second Amendment works exactly the same way. But they didn't stop at legal theory. The DOJ presented hard data that demolishes the public safety argument for permits. They showed that states eliminating permit requirements saw violent crime decrease, not increase. Texas removed permit requirements and watched violent crime drop 4% in the first year. Tennessee saw a 7% decrease over 2 years. Florida experienced similar results. The numbers directly contradict claims that permits keep communities safer. Over 25 states with constitutional carry laws have filed supporting briefs, the largest state coalition in Supreme Court history for any gun rights case. They're not making theoretical arguments. They're reporting actual results from their own communities. Crime didn't explode when permits disappeared. Law-abiding citizens didn't suddenly become dangerous. The dire predictions of gun control advocates simply never materialized. These states also exposed how permit systems create unconstitutional barriers for the most vulnerable Americans. When permits cost hundreds of dollars and require time off work for classes and applications, they become luxury items. A single mother working 2 jobs in a dangerous neighborhood can't afford the fees or the time. The very people who most need self-defense tools, those living in high-crime areas, are the ones priced out of their constitutional rights. But here's where this story takes a disturbing turn. Sources inside multiple state legislatures have revealed that anti-gun states aren't waiting for the Supreme Court's decision. They're already drafting legislation designed to circumvent any ruling that eliminates permits. These aren't rough concepts or theoretical discussions. Actual bills are being written right now, ready to be introduced the moment the court rules. The schemes being planned are both clever and cynical. California's draft legislation would eliminate the permit requirement, but replace it with a mandatory safety certification. This certification would require the exact same background checks, training requirements, fees, and waiting periods as current permits. They're literally just changing the name while keeping every restriction in place. Same gatekeepers, same delays, same denials, just different paperwork.
They really don't know what to do with this one, which is always a good thing to see.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
The one proposal allowing them to carry firearms without a license.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
Aimed at declaring various federal gun restrictions unconstitutional in the state.
Saying setting a higher threshold in an emergency could mean life or death.
We won't see changes overnight, but it's going to be quick.
New York's strategy draws from their playbook of dodging Supreme Court rulings. They've successfully changed their laws multiple times to avoid compliance with gun rights decisions. This time, they're preparing to eliminate formal permits while creating a web of alternative requirements that accomplish the same restrictions through different mechanisms. They've turned evading constitutional rulings into an art form. New Jersey's plan might be the most insidious. They're considering eliminating ownership permits entirely, complete with press conferences celebrating their compliance with the Supreme Court. But buried in the fine print would be a requirement for government approval on every ammunition purchase. You could own a firearm without a permit, but you'd need constant government permission to buy the ammunition that makes it functional. Every box of bullets would require a new background check and potential denial. Illinois is exploring a different approach, eliminating carry permits but requiring mandatory liability insurance. The genius of this scheme from their perspective is that the state wouldn't technically be denying anyone's rights. Private insurance companies would simply refuse to offer policies or price them so high that ordinary citizens couldn't afford them. The state gets to claim clean hands while achieving the same result through corporate proxies. Massachusetts wants to eliminate permits but require state-approved training courses before anyone can own or carry a firearm. The state would control which instructors receive approval, potentially ensuring only those with anti-gun views can teach. They could limit class sizes and availability, creating months-long waiting lists. You'd have a constitutional right that you couldn't exercise until completing training the state makes nearly impossible to access. Every one of these workarounds shares the same fundamental design. Government pre-approval remains, just channeled through different bureaucracies. Fees continue under new names. Background checks still control access. Officials retain power to delay or deny based on subjective criteria. The permit system would disappear in name only while its restrictions live on in new forms. Some legal experts believe these workaround bills could be introduced within 30 days of the Supreme Court ruling. The court might deliver what appears to be a landmark victory for gun rights, only to watch anti-gun states immediately restructure their systems to maintain the same restrictions under different labels. Years of additional litigation would be needed to challenge each new scheme. The Supreme Court could prevent this by writing an opinion broad enough to close these loopholes before they open. They could explicitly state that any system requiring government pre-approval before exercising Second Amendment rights violates the Constitution, regardless of what it's called. Any financial barriers, any government-controlled process that delays or denies rights, all unconstitutional. Clear language like that would make these workaround schemes dead on arrival.
That law has been in place since 1913.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
This case could reshape how far states can restrict your right to carry and where.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
When things sound really good for gun owners in court, that doesn't mean it's over.
This will get appealed, and this might go back and forth a little bit. But for right now, this is where we're at.
But even the broadest possible ruling faces an enforcement challenge. Some states have shown remarkable creativity in resisting Supreme Court decisions they disagree with. Federal lawsuits would likely be necessary to force compliance. The real battle might not be winning at the Supreme Court. It might be the years-long fight to make defiant states actually follow the ruling. For gun owners watching this unfold, the implications depend entirely on where you live. Those in constitutional carry states will see their current freedoms validated and protected by the highest court. But if you're in states like New York, California, New Jersey, Maryland, Hawaii, or Massachusetts, prepare for immediate resistance and creative attempts to maintain the status quo through different means. The next 90 days will be critical. State legislatures are in session, and the bills being drafted right now will determine whether this Supreme Court victory actually expands your rights, or whether anti-gun states successfully dodge it through legal gymnastics. This represents the most significant Second Amendment case in modern history, but the real battle over implementation is just beginning. What happens next will echo through generations. Either the Supreme Court successfully restores the Second Amendment to its intended place as a real constitutional right, or anti-gun states prove they can indefinitely resist and circumvent even the highest court's rulings. The outcome will determine whether constitutional rights mean what they say, or whether creative bureaucrats can always find ways around them. That's it for today, folks. See you in the next video.